Hello. This video introduces the subject of administrative law. It was produced for students on the final year Canadian Administrative Law module at the University of Sussex. But if you found yourself here because you're interested in introductory public law, then stick around, what you will learn is relevant. The video asks, what is administrative law? And while some of the material is Canada specific, it answers the question more broadly as well. So what is administrative law? A simple definition might be that administrative law is the branch of public law concerned with the administration of the state. That is, with the conduct of government. But it is more than that, because the idea of administrative law as a distinct branch of law is connected with the rise of the administrative state. We will say more about what that means in another video, but for now we can think of the administrative state as an understanding of the state as having an active role in the advancement of the public good. In the course of the 19th and 20th centuries, governments the world over took on a more comprehensive responsibility for the active management of the protection of the welfare of their citizens. And so the administrative state is the state that takes on such an active role. In the early years, before and after Confederation, these active measures were focused on the extension and protection of the frontier, as well as the development of the national economy. The Railway Acts of 1851 and 1903 and the Canada Grain Act of 1912 are examples. During the First World War, the emphasis shifted to intervention in the management of the economy, and this was further expanded as a result of the Great Depression, as Canada enacted several programs modelled after the US New Deal legislation. As an aside, Canada's New Deal programme was struck down by the Judicial Committee of the Privy Council. That is, the British House of Lords sitting as the highest court of empire, in the notorious ILO judgment written by Lord Atkin, who in the British context enjoys a reputation as a somewhat progressive judge. This ultimately led to Canada abolishing the appeal to the Privy Council, severing its connection with English law. This continued after the Second World War, but there was also an expansion of the administrative state into issues of social welfare. For example, in the Family Allowances Plan of 1944, old age security pensions established in 1952 are another example. And more recently still, there has been a further expansion into areas like anti-discrimination protection, for example in the Human Rights Act 1977. There were comparable developments in the UK, for example, the Factories Acts and Passenger Acts in the 19th century, the Railway and Canal Commission at the end of the 1880s, and in the 20th century things like the establishment of national insurance for unemployment, efforts to improve housing conditions or increase agricultural productivity. My mother had a small part to play in that, which is how she met my dad, who was a farmer. But that is another story for another day. Now, some of these programmes were administered by ministers of the Crown, but often they were administered by administrative agencies, like the Canadian Radio, Television and Telecommunications Commission or the Human Rights Commission. Often these bodies combined a legislative, rule-making function as well as an adjudicative dispute resolution function. In a later video, I will look at the reasons why it was considered desirable to combine these functions in a single body and some of the consequences of doing so. At other times, however, the machinery of the administrative state has taken the form of nationalized industries, or crown corporations in the Canadian parlance. These are bodies having legal personality separate from the Crown and which operate at arm's length from government. Since the 1980s, the number and significance of such bodies has declined through privatisation. And an interesting issue in administrative law is to what extent principles of administrative law should apply to privatised entities such as Air Canada. In other areas again, the government has established tribunals, an example of which is the National Labour Relations Board. This body is, in many respects, just like a specialised court. but it has a legislative mandate which explicitly includes taking account of industrial relations policy of government and current labour market conditions in reaching their determinations. These tribunals administer what a key work in the literature on the sociology of law calls responsive law, so called because this is a model of law in which the law is intended to be responsive to social needs. So we could say that administrative law is the law of these specialised administrative bodies. And that would be correct, but ambiguous. That expression could be used to denote the body of statutory law that establishes these public programmes and the legislative choices that go into the design of public programmes and the agencies or other organisational types that deliver them. Or the term could be used to denote the regulations and adjudicative determinations made by such bodies and the approaches to rulemaking and adjudication that such bodies take and why. And in fact, properly understood, administrative law encompasses both of these understandings of the field of administrative law. But for the purposes of this module, and the way that administrative law is understood on most undergraduate modules, at least in the common law world, we will adopt a slightly narrower understanding of the field. This narrower understanding is captured by the textbook we use, Gus Van Harten et al., which states that administrative law aims to unpack and distill the rules and principles that apply to all public decision makers and powers. The concerns of administrative law that will be emphasised in this module are general and can arise in connection with the administration of any statute or programme. So administrative law, as we understand the term in this module, is a body of general principles. And in fact, many of these principles are judge-made principles of common law, as much as they are statutory principles to be found in legislation, including the Constitution of Canada. But it is useful to bear in mind these other understandings as well, and we will refer to them from time to time in this module. Now, a question that is often asked is, what is the relationship between constitutional and administrative law? At the beginning of this mini-lecture, I said that administrative law was a branch of public law. Constitutional law, as you already know, is the other major branch of the subject. In fact, the two branches are not clearly separate. And as far as the design of university modules is concerned, the exact division between the two subjects is as much a matter of convenience as anything else. As a rough guide as to how we divide the material up at Sussex Law School, you could think of constitutional law as concerned with the validity of enacted law in terms of the compatibility with the Constitution. Administrative law, on the other hand, is concerned with ensuring the lawful implementation of validly enacted laws. An example might be helpful here and can be illustrated visually. Section 15 of the Canadian Constitution imposes a duty on federal government to protect citizens from discrimination. In furtherance of this duty, it introduces to Parliament, which approved the Human Rights Act of Canada 1977. We can refer to the Human Rights Act as the enabling statute because it enables or confers power on a body in order to carry out certain functions set out in the statute. The body is, in this example, the Human Rights Commission, which is authorised to investigate and settle complaints of discrimination. The role of administrative law is to ensure that decisions made by officials of the Human Rights Commission are in compliance with and do not exceed the authority granted to them by the Human Rights Act. But what is the extent of this authority? Can the Human Rights Commission investigate my business if it receives a complaint that I pay female employees less than male employees, for example? What processes must it follow as it investigates me? What measures can it order if it finds me guilty? The answer to the first question, incidentally, is yes, provided my business is regulated by the Federal Government of Canada. And this is a matter of looking up the statute. But on some matters the statute might be silent, or it might state some general principle about which there might be some penumbral uncertainty, or it might be outright unclear so that statutory interpretation alone offers little help. This is where the idea of administrative law as a body of general principles comes in. And the procedure by which the court assesses the compliance of administrative action, in this case by the Human Rights Commission, is called judicial review. And in a follow-up video, I will explain a bit more about what that involves and what the main grounds of judicial review are. Now, these questions can only be judged with reference to the Constitution, at least as a background consideration. In our example, this is partly because Parliament's purpose in passing the Human Rights Act was to provide the machinery through which the government could carry out its constitutional duty. So an understanding of the extent and limits of this duty could shed considerable light on what sort of decisions or actions by the Human Rights Commission Parliament had contemplated when it enacted the Human Rights Act. A couple of further points should be stressed though. First, unconstitutionality is itself a ground of judicial review of administrative action in Canada. Even in cases where the nexus between the Constitution and the responsibilities of an administrative decision maker is not as close as in the example, it is always open to parties to challenge the acts of an administrative agency on the ground that it breaches a provision of the Constitution. And an important principle that we will discuss in due course when we come to the case of Crevier is that the Constitution restricts Parliament and provincial legislatures from conferring certain adjudicative functions on administrative agencies if this offends against the constitutional allocation of judicial power set out in section 96 of the Constitution. Secondly, since the adoption of the Canadian Charter of Rights and Freedoms, it has become commonplace for Council to frame challenges to administrative decisions, both under Charter rights and the common law. For example, in relation to challenges to the fairness of the procedures followed by administrators, you will come across several instances where challenges have been brought both in terms of the common law of procedural fairness and the protection given to the principles of fundamental justice under Section 7 of the Charter. And there are good reasons for this. As the Canadian constitutional scholar Peter Hogg has put it, the common law rules of procedural fairness are in fact basic tenets of the legal system, and they have evolved in response to the same values and objectives of Section 7. So while the protections given by the two sources of law are not the same, it is not surprising that we should find a substantial area of overlap between them. But that is getting ahead of ourselves. For now, what I am trying to get across is an understanding of what administrative law is, both generally and in terms of this module. In summary, administrative law is, for our purposes, best seen as the body of general principles and legal doctrines that the courts use to control the exercise of administrative power. In Canada, perhaps more than the UK, the development of these principles and doctrines has responded to the growth of administrative agencies, and these are a central concern of administrative law, but by no means the only one. And because these principles and doctrines have often evolved in response to the same values and objectives as the Constitution, even when they do not directly derive from it, then there's a close nexus between constitutional law and administrative law.